This is in theory.
Today's lecture is going to be about something we call the institutionalist perspective. This is a perspective in Supreme Court decision-making that takes the view that when a justice decides a case, that his or her act of judgment is constrained. And there's going to be two different theories of where that constraint comes from. One is going to be a concern for setting off slack resources or opposition among the other branches of government or even the public. But that's not exactly what this lecture is going to be concerned with. This lecture is going to be concerned with something we call the internal constraints. And this is more controversial. This is sort of the Ronald Dworkin stuff. The law itself, that the justice is concerned with its text, its doctrine, its integrity, and that this has the effect of making the judge's decision in any particular case have a constraining factor.
You are listening to In Theory.
The critical view about Supreme Court decision-making tends to see the decision-making only in a two-dimensional universe, the outcome and its rationalization. Any outcome that the court gives you is always primary. For example, a woman's right to choose. You remember how the political perspective described this in terms of being pro-female. There is a suggestion in this critique that the judge is voting directly for this outcome. And so therefore, the rationalization is secondary, invented after the fact. The rationalization in this case, the Constitution having a right to privacy and abortion being included in that idea. The critical view is always going to see this as being a free pick and being primary, and this being something that simply gets constructed after the fact.
This is in theory.
Now there's going to be two replies that people are going to make. The reply that comes from the past goes like this. What the judges do is rationally find their way through a problem, and once they find the answer, out comes the outcome. And you'll notice the logic here would be they find the answer, not choose it. The suggestion here is there never was any choice at all. So this is very much a deductive model. Now, of course, the problem with the deductive model is that it doesn't seem to be true. And what I mean by that is, if it was true, if you had these judges, one being Democrat, another being Republican, another being Democrat, another being Republican, etc., and they all accessed the same sort of input material and engaged in this deduction, there shouldn't be much disparity. But in fact, there is. These people tend to argue for the vision that they have for the law. They very much disagree over whether the Constitution grants something or doesn't grant something, which frankly is quite natural. The deductive model is largely in service of what has become a discredited legal philosophy called classical legal thought. And this philosophy held that outcomes were dictated by the law. A legal problem was not unlike solving for X in mathematics. Put the word math there, where you would simply deduce and find the necessary result. And so, this school of thought largely became discredited over time due to a movement called realism. And realism left us with these two options here. Instead of the choice being dictated, the choice was either free or constrained. This school of thought is going to suggest that the rationalization and the outcome have an interesting bidirectionality. And remember, I told you, this was old, this was critical. This one is going to be much more modern. So let's look at that.
You are listening to In Theory.
The more modern school of thought holds that the problem isn't two-dimensional. What you have is three things. You have an outcome, and you have a judge crafting a reason. But these two things are not the only thing going on. There's also this thing here, which is the pre-existing policy. And so here's what the model is. You have a claimant who, when he or she goes into court, is asserting a claim about the law. That's very important to understand. The claim isn't, give me the right to do something. The claim isn't, give me the right to have all the guns that I want to have in my home. Give me the right to an abortion. The claim is never directly for these rights. The claim rather is something about the law. It therefore has a kind of story philosophy to it. What the claimant is saying is that the law says that you have this right. The law says this. Imagine like looking in a storybook. Chapter 5 says this. And so the problem is, philosophically, is there's been this darn intervention. Here's what I'm saying to you. To have a true attitudinal model, this person would have to directly be saying this. You'd have to be sitting like you're going before a council of kings or something. They're not going before authoritarians or autocrats who simply grant you something out of their grace and simply directly tell you that you can or can't do something. It's not like going to your parents. That's not what the setup is. There's this darn thing that gets in the middle.
This is in theory.
And so you have this concept here of a judge trying to figure out which inference is the best. There are rivals. The judge has to confront how his or her contribution can fit into the body of law, and that complicates the matter and makes his or her choice structured by something. And that's the key. We call this structured discretion. And so this project here in the institutional theory, this is a very serious question for the well-behaving judge. If the judge is well-behaved, picking this answer is intellectually important to him or her. And as a result, we start off with mere preference. Let's say Chief Justice John Roberts. Did he want Trump to win the election? Who did he vote for? Well, let's say he did vote for Trump. And let's say his mere preference was for Trump to win. After all, he's Republican. Well, now someone brings an election case to the court. And they say, hey, this election was funny in certain ways and the Supreme Court needs to get involved because election laws were violated. Okay, how does that work? What happens is it goes in the system and the outcome that's chosen is that the cases don't even get in the door. Justice Roberts says no thank you. And so the preference that Roberts has as a judge about whether these claims are meritorious ends up being very different from what's in his heart. That is what the institutionalist theory says. And we're going to show you some actual cases where we think we see this.
You are listening to In Theory.
So what we're talking about is intellectual behaviors that arise from marshalling, solving, reconciling, analyzing, critical reasoning, this kind of thing. And what's important about this activity is that we very much assume that it's done in good faith with sincerity. And there's also this, the worry about how the public, the profession, and history itself is going to think about what you're going to do on that piece of paper. Now, the one thing we have to note about this is that a lot of people have some pretty basic skepticism as to whether this really can be something that constrains a Supreme Court justice. I mean, think about it. Supreme Court justices are at the top of the food chain. They are not following legal precedent. What they're doing is creating it. And so, because they are engaged in an intellectual activity that is sort of declaring things, telling us what the law is, that there's a profound skepticism about that. But here's the point. This isn't a flaky theory. It actually seems to have some bit of truth to it. The question is, how much?
See more of Dr. Wilson's lectures here.
Go to seanwilson.us.